We've talked thus far merely about relevance in the abstract. When is something sufficiently probative of a fact that is at issue? In other words, when does something have any tendency to make a fact an issue more or less likely? And there are times when things will simply not be relevant. This is going to be less often than you might think. Quite often in court, you'll hear people jump up and say, "Objection, Your Honor, relevance." What they quite often really mean is that whatever relevant value this piece of evidence might have, it's outweighed by something else. Most everything has some tendency to make a fact at issue more or less likely, or why would we be talking about it? But when we ask the deeper question, whether the very small tendency that something has to make a fact at issue more likely is worth the waste of time, the confusion of the issues, or the thought that the jury might go down the wrong track with this piece of evidence, then that really is what we most often are talking about when we have objections to relevant testimony. So I'll let you take a look at the rule itself. This is Rule 403, and as you look at the rule, I want you to note how much wiggle room this is. We talk about lawyers' weasel words quite often, words that give an interpreter of a rule the power to go in all sorts of directions with it, gives the interpreter of the rule a certain amount of flexibility. Well, Rule 403 is absolutely a rule that has several weasel words in it. It's a rule that gives its interpreter a great deal of discretion. So look at the text of this rule. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needless presentation of cumulative evidence. So what's really interesting about that is that even if the court finds that the prejudice from confusing the issues, or the prejudice from the possibility of misleading the jury or wasting time, any number of things that could cause the evidence to the prejudicial impact of the evidence to substantially outweigh the probative value, the court is then not even still required to exclude the evidence. It simply may do so. So Rule 403, what you should take from this is that it has its thumb strongly on the scale of admissibility, or on the side of the scale of admissibility. The federal rules of evidence, when they were drafted in the 70s, really tried to encourage more and more things to be admitted. Now, you might look at Rule 403 and say it has absolutely no teeth whatsoever, that if a trial judge just chose to let everything in, 403 would pretty much let him do so. And that's an exaggeration. The rule implies such a thing, but when you look at the appellate cases we'll look at in this course and in this section, you'll find that appellate courts actually do with some frequency reverse trial courts for failing to exclude evidence under Rule 403. But the key thing to note here is that there is a balance between probative value, those things that have any tendency to make a fact at issue more or less likely, and then this prejudicial impact, this confusion of the issues, these things that might cause the jury to hate the defendant for reasons unrelated to whether or not he committed the crime, cumulative evidence, waste of time. When those things outweigh the probative impact or the probative value, that's not enough to throw it out. You can only throw out the evidence if the prejudicial impact substantially outweighs the probative value. So as in all things we'll look at in the rules, you'll find that there is a strong tendency to admit evidence, but you have to go through this balance and keep your eye on the ball. There will be times when the rules of evidence will change this balance slightly with the prejudice and probative sides of it, with some impeachment issues that we will get to later. And those rules will change for criminal and civil defendants. So keep your eye on this space. But the key thing right now is that at an initial level, you will always be balancing the probative value against the potential prejudice of the evidence, knowing that the potential prejudice has to substantially outweigh the probative value before a court can even consider not admitting that evidence.